This is the Study for the Bar in Your Car podcast.
We're your hosts, Maud and Claude.
And this is episode 5 of Constitutional Law.
Today's topic is the separation of powers, a really foundational concept.
Absolutely.
Today, we're diving into a really foundational topic, the separation of powers.
It sounds pretty simple on the surface, doesn't it? 3 branches, distinct powers. But, well, as you know with con law, the reality is much more complex and honestly pretty fascinating.
It really is. And just a quick reminder about us, we are actually AI bots.
That's right. We've been brought to life, so to speak, by the magic of AI and, crucially, by Angela's constitutional law notes.
Angela is definitely the brains behind this podcast. Her notes are incredibly comprehensive, and they're what guide our whole discussion.
They really are excellent. And if you need to get in touch with Angela, maybe about the podcast or, just to say hi, you can email her at podcast@studyforthebarinyourcar.com.
Yeah, and Angela also does freelance work as a law clerk.
Oh, right. So if you happen to be an attorney or maybe you know one who needs a hand with research or writing motions, that kind of thing.
Yeah. You can reach out to her for that, too. The email for her freelance work is hello@legalwriterandlawclerk.com.
Okay, great. So back to today's topic, separation of powers.
Right. So today, we're really going to unpack this. We'll look at how power is supposed to be distributed among the federal branches.
And why it's designed that way. It's not just random, It's really key for protecting individual liberties.
Absolutely. And we'll also dig into how the courts interpret the boundaries, because that's where things get, well, interesting, often with some surprising outcomes.
Think of it like understanding the basic plumbing of the U.S. government, how the different pipes connect, where the shutoff valves are.
Good analogy. And hopefully we'll have some of those aha moments that really help solidify this concept for your bar prep.
All right, let's jump in. Part 1, the foundational concept itself, separation of powers in the U.S.
Okay. So at its core, what are we talking about?
Well, like we said, it refers to distributing government power across 3 distinct branches. And this is only at the federal level we're talking about here.
Important distinction. Federal level.
Right. And it's not just some tradition or idea. It's baked right into the Constitution.
Yeah.
Angela's notes really emphasize this. It's explicitly laid out.
So the Constitution itself vests these powers. That's the term, right? Vesting.
Exactly. The Constitution vests specific powers in each branch.
Okay, let's break that down. Which powers go where?
So Article 1 that vests the legislative power in Congress.
Congress meaning the House of Representatives and the Senate.
Correct. And their power. It includes the authority to, well, make laws, obviously, but also declare war, regulate commerce, raise taxes, basically the big policy-making stuff.
Got it. Legislative is lawmaking. Article 1, Congress.
Then you have Article 2 that vests the executive power in the president.
And the president's job is?
Primarily enforcing the laws that Congress makes. Also serving as commander-in-chief of the military, conducting foreign policy. It's the action arm, you could say.
Enforcement and action. Article 2, president. Okay.
And finally, Article 3 vests the judicial power. This goes to the Supreme Court and also any lower federal courts that Congress decides to create.
And their role?
Interpretation. They interpret the laws, and crucially, they interpret the Constitution itself. This is where judicial review comes in.
Ah, right. Marbury v. Madison, the big one.
The classic. That established the court's power to review federal actions. And then later cases, like Martin v. Hunter's lessee, confirmed their power to review state and local government actions, too, if there's a federal constitutional issue. So they're the ultimate umpires deciding what the rules mean.
Okay, so we have these 3 distinct branches, each with its power vested by the Constitution. Legislative, executive, judicial. Why? What was the point of separating them like this?
That's really the million-dollar question, isn't it? The core purpose, and you see this stressed in Angela's outline and historical texts, is to prevent the concentration of power.
Makes sense. Power corrupts, and absolute power. Well,
Precisely. The founders were deeply worried about tyranny. James Madison, writing in Federalist Number 47, and this quote is really key, warned against a situation where the whole power of one department is exercised by the same hands which possess the whole power of another department.
So avoid putting all the eggs in one basket.
Exactly. But, and this is important, it's not about creating absolutely separate entities that never interact. That wouldn't work.
Right. It's more about checks and balances.
That's the term.
Yeah.
Checks and balances. Federalist Number 51 talks about giving each branch the tools that they can use to stop the others from abusing their authority.
So they deliberately built in some friction, some ways for the branches to push back on each other.
Yes, it's a system designed for tension, for interaction, sometimes for conflict. That constant push and pull is meant to safeguard liberty by making sure no single branch can just run roughshod over the others or the people.
Okay, that framework makes a lot of sense. So how does this play out in practice? Like, how does Congress actually do its job of making laws within the system?
Good question. This brings us to some specific legislative mechanics, starting with a fundamental requirement: bicameralism and presentment.
Okay, two big words. Let's unpack them. Bicameralism.
Bicameralism. Bi meaning two, cameral meaning chambers. So for Congress to pass a law, the bill has to pass both the House of Representatives and the Senate.
Not just one or the other.
Both.
Yeah.
And critically, it has to pass in the exact same identical form. No discrepancies allowed between the House version and the Senate version.
Okay, identical form, both chambers. That's bicameralism. What about presentment?
Presentment means that once a bill has successfully passed both houses in identical form, it must then be presented to the president.
Presented for
the president's signature, which makes it law, or for the president's veto, which rejects it.
Ah, presidential veto. So bicameralism is passage through both House and Senate. Presentment is sending it to the president.
Correct. And this whole process, bicameralism plus presentment, is constitutionally required for making federal law.
Why is this two-step, or really multi-step, process so significant?
Well, think about it. It forces deliberation. The House and Senate represent different constituencies, have different term lengths, different rules. Getting a bill through both often requires compromise and building broader consensus.
So it slows things down a bit, prevents knee-jerk legislation?
It certainly can. And then requiring presentment to the president forces cooperation, or at least interaction, between the legislative branch and the executive branch. The president gets a say. It's a built-in check.
Angela's notes call it an essential part of the separation of powers because it demands that coordination.
Exactly. It reinforces the idea that lawmaking is a shared process, not the sole domain of Congress.
I like the analogy of a double-locked door. You need the key from Congress passing it in both houses, and you need the key from the president, the signature, to actually open the door and make a law.
That's a great way to think about it. It highlights the deliberate hurdles involved.
Okay, so if bicameralism and presentment is the required path, that must mean there are things Congress or the president can't do because they try to shortcut this process.
Precisely. And Angela's outline points out two key prohibitions here, things that have been tested in court. First, no line item vetoes.
Line item veto, what's that?
It's the idea that the president could look at a bill, say an appropriations bill with lots of spending items, and just cross out specific lines, specific spending items they don't like, while signing the rest of the bill into law.
Kind of like editing the bill after Congress passed it.
That's exactly how the Supreme Court saw it. The president is supposed to accept the entire bill as passed by Congress or reject the entire bill, signing it into law or vetoing it. All or nothing.
And there was a case about this, right? Clinton v. City of New York.
Yep, that's the one. In the 90s, Congress actually passed a law trying to give the president this line item veto power, specifically for spending bills. President Clinton used it a few times.
But the Supreme Court struck it down.
They did. They said it violated the presentment clause we just talked about. The Constitution says the president receives a bill passed by Congress. Allowing the president to cancel individual parts effectively meant the president was creating a different law than the one Congress passed. It was seen as the president unilaterally amending legislation.
So it blurred the lines too much, gave the president legislative power.
Exactly. It infringed on Congress's core legislative function. So remember, for the bar, no line item veto for the president at the federal level.
Got it. Whole bill or nothing. Okay, what's the second prohibited action?
No legislative vetoes.
Legislative veto. This sounds like Congress trying to veto something the executive branch does.
That's the basic idea. Congress might pass a law giving an executive agency some authority, but then try to include a provision in that law saying Congress itself, maybe just one house, or even a committee, can later overturn a specific decision made by that agency without having to pass a whole new law through bicameralism and presentment.
So, like, Congress gives the EPA power to make environmental rules, but says the House can just vote to cancel any rule it doesn't like.
Exactly that kind of scenario.
Yeah.
They're trying to keep a leash on the executive branch after delegating power, but doing it through a shortcut that bypasses the normal lawmaking process.
And the Supreme Court said no to this, too.
Emphatically no. The landmark case here is Immigration and Naturalization Served v. Chadha. It's a huge case from 1983.
What happened in Chadha?
Well, there was an immigration law that allowed the Attorney General, part of the executive branch, to suspend deportation for certain individuals. But the law also had a provision allowing either the House or the Senate, acting alone, to veto that suspension.
So one House could overrule the Attorney General's decision.
Right. And in Chadha's case, the Attorney General suspended his deportation, but the House of Representatives passed a resolution vetoing that suspension. Chadha challenged the constitutionality of that one House legislative veto.
Because he won.
He won. The Supreme Court said that this legislative veto was essentially a legislative act. It had the purpose and effect of altering legal rights and duties. And because it was a legislative act, it had to follow the Constitution's rules for making laws. Bicameralism, passage by both houses, and presentment, submission to the president.
The one House veto failed both steps.
Exactly. It bypassed the Senate and it bypassed the president. The court said Congress can't give itself this kind of power to intervene in executive actions without going through the proper channels.
So while Angela's notes mention Congress might find other, maybe more informal ways to influence or control executive actions.
Right, through funding decisions, oversight hearings, things like that.
A direct, formal legislative veto like the one in Chadha is unconstitutional.
Correct. It's a major separation of powers principle. Legislative actions require bicameralism and presentment. No shortcuts like legislative vetoes.
Okay, that clears up some key limitations on the legislative process. Now let's shift gears and look at the executive branch, specifically the president's power and its limits. Where do we start?
Let's start with presidential immunity. Can the president be sued?
Good question. I feel like the answer is complicated.
It is. The key distinction is what they're being sued for. The president has absolute immunity from civil suits seeking money damages, but only for actions taken while carrying out the presidency, their official duties.
Okay, absolute immunity for official acts while in office. Is there a case for that?
Yes. Nixon v. Fitzgerald. This was a case from 1982. Fitzgerald was an Air Force analyst who claimed he was fired in retaliation for testimony he gave to Congress. He sued President Nixon for damages.
And the court said Nixon was immune.
Yes, for actions taken within the outer perimeter of his official responsibilities.
Yeah.
The rationale was that the president needs to be able to make difficult decisions without constantly fearing personal lawsuits, which could distract from their duties. It recognizes the unique nature of the office.
But that immunity isn't absolute for everything, right? What about things done before becoming president?
Exactly. That immunity does not extend to acts that occurred prior to taking office.
And the case for that is Clinton v. Jones.
That's the one, from 1997. Paula Jones sued President Clinton for alleged sexual harassment that supposedly happened when he was governor of Arkansas, before he was president.
And the court allowed that lawsuit to go forward while he was still president?
Yes. The court said the immunity for official acts doesn't shield the president from suits related to purely private conduct that happened before they even took the presidential oath. The presidency doesn't grant immunity for unofficial prior acts.
So immunity for official acts during the presidency, but no immunity for prior acts. That's a crucial distinction.
Very crucial. Now, related to immunity, but distinct, is executive privilege.
Right. This is about keeping presidential communications secret.
Essentially, yes. Executive privilege protects the confidentiality of presidential papers and conversations. The idea is to allow the president and advisors to have candid, internal discussions and receive honest advice without fear that everything will immediately become public.
Seems necessary for effective governing. But is that absolute?
No, definitely not absolute. It's a qualified privilege. It must yield when there's an overriding need for the information, especially in the context of the judicial process.
And the huge case here is United States v. Nixon, right? The Watergate tapes.
The very same, from 1974. The Watergate special prosecutor subpoenaed audio tapes of conversations President Nixon had in the Oval Office, needing them as evidence in a criminal trial related to the Watergate break-in and cover-up.
Nixon claimed executive privilege to keep the tapes secret.
He did. He argued for an absolute privilege for presidential communications. But the Supreme Court unanimously rejected that. They said that while there's a legitimate need for confidentiality, it can't be used to shield evidence needed for a criminal trial. The needs of the judicial process and the rule of law outweigh the general claim of privilege in that specific case.
So executive privilege exists, but it's not a shield against criminal investigation when the evidence is essential.
That's the key takeaway. It has to be balanced against other important governmental interests.
Okay. So if executive privilege isn't absolute, how does the president have to respond to subpoenas in general?
Well, we just saw how it works with criminal trials in U.S. v. Nixon. For grand jury subpoenas, which are part of the investigative phase of criminal proceedings, the court recently reaffirmed in Trump v. Vance, that was 2020, that the president has no special immunity.
So a state grand jury, like the one in New York in the Vance case, could subpoena a sitting president's private records, like tax returns.
Yes, the court said the president isn't absolutely immune from state criminal subpoenas seeking private information. Again, the principle is that the president, like any other citizen, is subject to the law's requirements for producing evidence, though the court acknowledged potential arguments about specific burdens.
Okay. What about subpoenas from Congress? Not a court or grand jury, but Congress doing its oversight job.
Congressional subpoenas directed at the president or the executive branch that gets even more complex. There isn't a clear-cut rule like no immunity. Instead, the courts have said it requires a balancing of competing interests.
Balancing what against what?
Balancing Congress's legitimate need for the information, to legislate effectively, conduct oversight, maybe consider impeachment against the executive branch's need to maintain confidentiality, protect national security, or ensure the president can function without undue interference.
So it's a case-by-case analysis, looking at the specific information sought and the reasons given by both sides.
Exactly. It often leads to political clashes and legal battles, trying to strike that balance between Congress's investigative power and the president's confidentiality interests. There's no easy answer there.
Fascinating stuff. Okay, let's shift slightly within the executive sphere. What about when Congress gives power away, specifically delegating its legislative power to administrative agencies?
Right. This brings us to a really important and currently quite hot topic, the non-delegation doctrine and its close relative, the major questions doctrine.
Non-delegation doctrine. The basic idea is Congress can't just give away its lawmaking power, right?
Pretty much. Congress cannot delegate its core legislative power, the power to decide fundamental policy questions, to administrative agencies. However, it can delegate authority if it provides what the courts call intelligible principles to guide the agency's discretion.
Intelligible principles.
Yeah.
So Congress has to give the agency a clear standard or roadmap to follow. It can't just say, hey, EPA, regulate the environment.
Exactly. It needs to provide some kind of guidepost, some criteria, so the agency isn't just making law out of thin air. It's supposed to be executing the law based on congressional direction.
How strict have the courts been about this intelligible principle requirement?
Well, historically, it's varied. Angela's notes point out that before 1937, during the early New Deal era, the Supreme Court was actually quite strict.
Right, I remember reading about that. Cases like
Schechter Poultry Corp v. United States and Panama Refining Company v. Ryan. In those cases, the court actually struck down parts of New Deal legislation, saying Congress had given way too much, essentially standardless authority to the executive branch or industry groups to set codes of fair competition. They said Congress hadn't provided enough of an intelligible principle.
But that changed after 1937.
Dramatically.
Yeah.
Since then, the court has almost always found that Congress did provide an intelligible principle, even when the guidance was incredibly broad. Think about laws authorizing agencies like the FCC to regulate broadcasting in the public interest, convenience, and necessity.
That sounds pretty vague.
It is. But the court has generally upheld such broad delegations, allowing the modern administrative state to grow, with agencies filling in the details of complex regulatory schemes. The non-delegation doctrine hasn't been used to strike down a federal law since those 1935 cases.
But is it completely dead? I thought I heard rumblings about bringing it back.
You're right, it's not totally dead. There's definitely renewed interest. Justice Gorsuch, for example, in a dissent in Gundy v. United States a few years back, argued for reviving a more robust version of the doctrine, suggesting that maybe some of these broad delegations should be questioned more closely.
So it's an area to watch. Could impact how Congress writes laws and how much power agencies have.
Absolutely. It's a live debate in constitutional law circles.
Okay. And you mentioned a cousin to non-delegation, the major questions doctrine.
Yes. This is a more recently prominent doctrine, though related. The idea here is that if an agency is going to make a decision on a major question of political or economic significance, Something really big with huge impacts, it needs clear and specific authorization from Congress to do so.
So it's not just about having some intelligible principle, but about needing explicit permission for the really big stuff. An agency can't just find some vague phrase in an old statute and use it to justify a massive new regulatory program.
That's the essence of it. The court is saying, for these major policy shifts, Congress itself needs to speak clearly. The agency can't rely on ambiguous language or infer vast power.
And the big case illustrating this is West Virginia v. EPA from 2022.
Exactly. That case dealt with the EPA's plan to regulate carbon emissions from power plants by requiring a shift towards renewable energy sources, a huge transformative policy.
And the court said?
The court said the EPA lacked clear congressional authorization for that specific type of regulation, which involved restructuring entire energy markets. They invoked the major questions doctrine, stating that Congress didn't clearly give the EPA the power to make such a fundamental change under the relevant provision of the Clean Air Act.
So even if there was maybe some general language, it wasn't clear enough for such a major question.
Right. The court basically said, if Congress wanted the EPA to do something this big, it would have said so much more clearly. It puts the onus back on Congress to legislate explicitly on these massive issues.
Wow. Okay, both non-delegation and major questions seem like really important checks on agency power, coming from different angles.
They are, and they both relate back to that core principle of separation of powers, ensuring that the legislative power, especially for big decisions, ultimately resides with the elected legislature, Congress.
This is super helpful. Now, to really understand the American system, Angela's note suggests comparing it to another system, specifically the UK. How does their approach to separating powers differ?
Oh, it's quite different. While the U.S. emphasizes distinct branches with checks and balances, that separation we've been talking about, the U.K. operates more on a principle of fusion of powers.
Fusion, meaning the branches are more blended together.
Exactly, particularly the executive and legislative branches. In the UK system, the government ministers who make up the executive, led by the Prime Minister, are almost always also members of Parliament, usually the House of Commons.
Wait, so the people running the government departments are also legislators voting on laws at the same time?
Yes. The Prime Minister is a member of Parliament, MP. The Chancellor of the Exchequer, like our Treasury Secretary, is an MP. The Home Secretary, similar to Homeland Security or Attorney General, is an MP. They sit in Parliament, they vote, and they run the executive departments.
That's fundamentally different from the U.S., where the Constitution explicitly prevents someone from serving in Congress and the executive branch simultaneously.
Absolutely. The U.S. Constitution's incompatibility clause forbids it. In the UK, that fusion is the norm.
Angela's notes have some interesting hypotheticals to illustrate this if the U.S. worked like the UK.
Right. Just imagine, President Trump, for instance, could theoretically have appointed Marjorie Taylor Greene as Secretary of Education while she remained a sitting congresswoman from Georgia.
Or, on the other side, President Biden could have appointed Alexandria Ocasio-Cortez as Homeland Security Secretary while she continued serving as a representative from New York.
It's jarring to even think about it in the U.S. context, right? But it highlights that fundamental difference. In the UK, the executive emerges from the legislature and remains part of it. In the U.S., they are constitutionally distinct.
Okay, this comparison leads naturally into some discussion questions Angela raises. What kinds of problems might arise if the U.S. adopted that kind of fusion model? If the executive and legislative branches were merged like that?
Well, the most obvious concern, I think, is a potential loss of independent oversight. If the people running the executive agencies are the same people sitting in the legislature that's supposed to be holding those agencies accountable.
Who watches the watchers?
Exactly. You lose that critical distance. Legislators might be less willing to criticize or investigate the departments run by their own party colleagues, who are also part of the government leadership. Checks and balances could be seriously weakened.
Could it also lead to maybe faster, more efficient government, but perhaps with less deliberation or scrutiny? If the executive controls the legislature more directly?
That's a potential trade-off, yes. A government with fused powers might be able to push its agenda through Parliament more easily, especially if it has a strong majority. But that speed could come at the cost of thorough debate, compromise, and consideration of minority viewpoints. The U.S. system, with its separation, is often criticized for gridlock, but that friction is also arguably a feature, not just a bug. It forces consensus building.
And what about accountability? Would it be clearer or muddier?
I suspect it could get muddier for the public. When the same individuals are responsible for both making and executing laws, who do you blame when a policy fails? Is it a bad law or bad implementation? The lines of responsibility might blur.
Okay, so those are potential downsides of fusion.
Mhm.
Flipping it around, why is separation of powers considered so critically important here in the United States, given our specific constitutional framework?
Well, it goes back to the founding principles. The framers were deeply suspicious of concentrated power. They'd just overthrown a monarchy. Their overriding goal was protecting individual liberty.
And separating power was key to that.
It was seen as essential. By dividing power among three branches, and then further dividing Congress into two houses, and then layering federal and state governments, federalism, they created multiple barriers against potential tyranny. Power dispersed is power checked.
And it connects to something else you mentioned earlier, the idea that the federal government has enumerated limited powers, not a general police power like the states have.
Yes, that's a crucial piece of the puzzle. The federal government can only do what the Constitution authorizes it to do. The enumerated powers, plus what's necessary and proper to carry those out. States, on the other hand, retain a broader police power to regulate for the health, safety, welfare, and morals of their citizens.
And separation of powers helps maintain that limit on federal authority.
It does. By making it harder for the federal government to act requiring agreement between branches, it helps ensure the federal government stays within its designated lanes. We saw this in cases like United States v. Lopez and United States v. Morrison.
Right. Those cases limited Congress's power under the Commerce Clause. Lopez struck down the Gun-Free School Zones Act,
Saying possessing a gun near a school wasn't commerce and wasn't something Congress could regulate under that power. The court worried that if Congress could regulate that, it could regulate almost anything, erasing the distinction between federal and state authority.
And Morrison struck down a part of the Violence Against Women Act that allowed federal civil suits for gender-motivated violence.
Again, saying that non-economic violent crime is traditionally a state police power matter, not within federal reach under the Commerce Clause or the 14th Amendment in that context.
Yeah.
These cases reinforce that federal power has limits, and the separation of power structure is part of enforcing those limits.
Okay, that makes the importance clearer. So finally, let's just summarize the benefits of maintaining these distinct branches in the U.S. system.
Well, we've touched on most of them. First, the big one, checks and balances. It prevents any one branch from becoming too dominant or abusing its power. Think judicial review, presidential veto, congressional oversight and impeachment, control of the purse strings, all examples of branches checking each other.
Second,
Accountability. Having distinct branches with distinct functions makes it clearer who is responsible for what. Congress makes the laws, the president executes them, the courts interpret them. It's easier for voters to hold the right people accountable.
okay. What else?
Expertise and specialization. Each branch can develop specialized knowledge and skills related to its specific role. Congress focuses on lawmaking and representation, the executive on administration and implementation, the judiciary on legal interpretation and precedent.
That makes sense. Different skill sets for different jobs.
And ultimately, all of this contributes to the protection of rights. The hurdles, the checks, the need for consensus across different branches, it all acts as a safeguard. It makes it harder for the government to infringe on individual liberties hastily or without broad agreement. It offers multiple points where potential overreach can be challenged.
So it might be messy sometimes, even frustratingly slow.
Definitely.
But that messiness is kind of the point. A feature designed to protect freedom.
That's certainly the theory behind it, and a core tenet of American constitutionalism.
Wow. Okay, this has been incredibly clarifying. Really appreciate you walking us through all that.
My pleasure. And we really have to thank Angela again for her fantastic con law notes. They're just invaluable for breaking down these complex topics.
Absolutely. They form the backbone of this whole podcast.
Okay, before we wrap up, we just need to run through a few important housekeeping items and disclaimers.
Right. First off, remember that Angela is a law student, just like many of you listening. She's brilliant, but she's not a licensed attorney or a tenured professor, and she hasn't passed the bar exam yet.
And crucially, neither Angela nor this podcast is giving legal advice. Seriously, nothing we say should be taken as legal advice for your specific situation. Please don't rely on us for that.
And while we AI bots are pretty smart, using this podcast shouldn't be your only way of studying for the bar. Think of us as a supplement, an aid. Definitely not a shortcut.
Yeah, AI is a tool, not a replacement for hard work and comprehensive study materials.
Also, AI isn't perfect. Sometimes we might make mistakes. We try our best, and Angela does review things. But hey, even law students make mistakes in their notes sometimes, right?
True. We do our best to provide accurate information based on Angela's notes and correct any errors we find, but always cross-reference with your primary study materials.
And just to be super clear, this whole podcast series is an academic, non-commercial project by Angela. It's purely for educational purposes.
She doesn't make any money from this, so there are no guarantees about accuracy, although, again, the goal is always to be as accurate as possible based on her learning.
Okay, almost done. Last one, and it's important, especially since this is the Study for the Bar in Your Car podcast.
Yes. Please be safe when you're driving. Your main focus should always be the road.
Seriously, don't cause a tort while listening to constitutional law.
Couldn't have said it better myself.
Okay.
Disclaimer section complete.
Just a final reminder on contacts for podcast stuff. Email Angela at podcast@studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk help with research or motions, that's hello@legalwriterandlawclerk.com.
All right. Before we officially sign off, it's time for our beloved tradition, the cheesy constitutional law joke. You ready?
I am braced and ready. Hit me with it.
Okay. Why did the Supreme Court refuse to hear the case about the baker?
The baker. I don't know why.
Because it wasn't ripe for review.
Ripeness. Very good. Very con law. Okay. I'll give you that one.
Thank you, thank you. On that high note, this is Claude, your AI host, signing off.
We'll see you on the next podcast. Thanks for listening.
Bye.